All right, I originally got this question in Spanish, but I thought I'd answer it in English as well, which is, can they approve your I-130 if you have a permanent bar? And the answer is yes. And the reason is that your I-130 just establishes the relationship necessary to later go on and either do an adjustment of status or a consular process with a waiver. In other words, it is only establishing that you have the required relationship to then seek a green card, or for the petitioner to seek a green card on your behalf, right? So that's all they're looking at. They're not looking at entries. You could be perm barred. In fact, I-130s are approved with removal orders. So all of that, they assume you're going to take care of later at some point. They're not looking at criminal history, none of that. They are only looking at, is this a bona fide relationship? The one exception I would say is if there is a criminal history on behalf of the petitioner under the Adam Walsh Act of sexual abuse against a minor, they could not approve the I-130, questioning whether or not, there's abuse in the marriage. But other than that, I-130 literally only takes into account the familial relationship, not just husband-wife, husband-husband, wife-wife, not just spousal relationship, also parent-child relationship, brother-sister relationship. All of those relationships are what are evaluated in the I-130, and that then later, upon approval, you can take the approved I-130 and say, okay, now I'm eligible for, a consular process or for adjustment of status or whatever it is that you're doing. And then we can address an admissibility concerns, criminal history, immigration history, all the rest in that process. So an I-130 being approved is not indicative of your green card being approved.